this video, we'll look at refusal to undertake an education, health and care needs assessment decisions in more detail. We will look at the legal test which is used to make decisions about EHC needs assessments and your options following a refusal to assess decision. The legal test is the only test which the local authority can use when making decisions about education, health and care needs assessments. The legal test is a two-part test set out in Section 36 of the Children and Families Act, and both parts must be met before the local authority can agree to a needs assessment. This is the legal test. The local authority must secure an EHC needs assessment for the child or young person if A. the child or young person has or may have special educational needs, and B. it may be necessary for special educational provision to be made for the child or young person in accordance with an EHC plan. It's important to be aware of the word may have special educational needs and may require provision in line with an EHCP. The bar or threshold to meet this test is very low. The legal test for a needs assessment is not whether the child or young person definitely has SEN or that they definitely need an EHCP. It's whether they may need special educational provision through an EHCP. The local authority has an anticipatory duty. This means that they should not be looking at what is in place now, but what may need to be in place to support that child or young person in the future. If support or provision are not in place, that does not automatically mean that your child or young person doesn't need it. It only means that they're not receiving it. However, it's also important to be aware that all schools are expected to support children and young people within their settings. The local authority will be looking for evidence that the school has followed the graduated approach. This is a cycle of assess, plan, do, review. You can find out more information about this in the video description. We would advise you to first speak to your education provider to find out what evidence they are able to provide to the local authority. If the setting has not followed the assess, plan, do, review cycle or provided any evidence, then there may have been little evidence for the local authority to consider the second part of the legal test. You can speak to them about what additional support they can offer or what more evidence they can gather. You can submit a new request at any point, but bear in mind you will need more evidence or different evidence to what you submitted this time. You also have the option to attend mediation or lodge an appeal with the SEND Tribunal, and let's look at these options in more detail. Mediation is a less formal way of resolving the dispute between yourself and the local authority. It involves an online meeting between yourselves as parents, a representative from the local authority, and a trained mediator. The mediator is impartial and is there to facilitate discussions to make sure everyone is treated fairly and that the statutory guidelines are being followed. Mediation meetings don't always lead to the issue being resolved, but sometimes they do. If an agreement is reached, this will be written down in what's called a mediation agreement. This is a contract between you and the local authority and it's binding. If an agreement is not reached, you will be issued with a mediation certificate and you will be able to lodge an appeal with the SEND Tribunal if you want to. You can also obtain a mediation certificate without attending a mediation appointment if you prefer. You will need a mediation certificate if you want to lodge an appeal. You will need the local authority decision letter to arrange a mediation appointment or to request a mediation certificate, so it's important to keep it somewhere safe. We have another video about mediation on our YouTube channel which goes into more detail about how to prepare for the meeting and what to expect. You may feel that you have provided adequate evidence to meet the legal test threshold. In some cases, you may have limited evidence due to the situation, but the evidence you do have could be significant in relation to the legal test. For example, the attendance record for a child or young person who is out of setting for an extended period due to unmet need, information from an alternative provision provider if one is being used, letters sent when there are regular suspensions and if there is a risk of permanent exclusion, the extended use of reduced timetables due to a setting not being able to support a child or young person. Your deadline to lodge an appeal is 2 months after the date on the local authority decision letter or 1 month after the date on the mediation certificate, whichever is later. You can lodge a late appeal, but a judge has to consider if your appeal should be registered, which can add further delays. If you want to appeal against a refusal to assess decision, you will need a mediation certificate. This shows that you have either been through the mediation process and it's not resolved the dispute, or that you have received information about mediation and decided you don't want to attend a meeting with the local authority. You need to have at least considered mediation as an option before lodging an appeal against a refusal to assess decision. For a refusal to assess appeal, you will need to complete a Send 35A form, and we have videos on our YouTube channel which explains how to complete the form.